Call this meeting back to order. We had several items on the executive session calendar. Council, please.
Yes, Mr. Chairman. Item number 5 on the regular agenda concerns the recovery of Pima County's excess cost related to water service to the new Justice Court complex. In order to preserve the county's interests, the county attorney seeks authority to execute a tolling agreement on behalf of Pima County if such arrives in a timely fashion, or otherwise authorization to file a complaint.
Move that recommendation.
Second.
Motion and a second to move and approve the recommendation. Any discussion? Hearing none, those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Council.
Mr. Chairman, members of the board, turning to the addendum agenda, item 1 on the addendum agenda concerns First American Title Trust number 9291 versus Pima County, case number TX 2012-845, pending in the Arizona Tax Court. This litigation involves 21 residential lots for the tax year 2013 in a subdivision known as Stone Canyon, located in unincorporated northwest Pima County. The 21 lots total approximately 27.5 acres. One of the parcels will be dismissed from the lawsuit as part of the proposed settlement. Upon the estimated overall tax decrease for the remaining 20 parcels under the settlement is $31,320 for tax year 2013 based on 2013 tax rates. The settlement values for the 20 parcels for tax year 2013 will not roll over to tax year 2014 because the notice values for 2014 are lower than the settlement values for tax year 2013. The Assessor and County Attorney's Office recommend the proposed settlement.
Move the county attorney and assessor's recommendation.
Motion and a second to approve the county attorney and assessor's recommendation. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Council.
Yes, Mr. Chairman, members of the board, item 2 on the addendum agenda was continued. Item 3 on the addendum agenda concerns Ina Business Center LLC versus Arizona Limited Liability Company versus Pima County. This is case number ST 2012-790 in the tax court. This litigation involves a challenge to the valuation of commercial property located at 3390 West Ina Road. The proposed settlement would result in an estimated tax decrease of $28,244.96 for the 2013 tax year based on 2012 tax rates. The values for 2013 tax year will roll over to 2014 tax year pursuant to the statute. Each party will bear their own costs and attorney's fees in the litigation. The assessor and the county attorney recommend the settlement.
Move the county attorney and assessor's recommendation.
Motion and a second to approve the county attorney and assessor's recommendation. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Council.
Mr. Chairman, members of the board, item 4 on the addendum agenda concerns GIT Tucson number 2 LLC versus Pima County. This is case number TX 2012-792 pending in the Arizona Tax Court. This is for litigation. Litigation is for tax years 2012 and 13 and involves an apartment complex comprised of 408 units located at 373 North Wilmot Road in Tucson. Under the proposed settlement, the estimated total tax decrease for the 3 parcels is $16,390 for tax year 2012 based on 2012 tax rates, and $17,205 for tax year 13 based on the 2013 tax rates. The settlement values for the 3 subject properties for 2013 will not roll over to 2014. The assessor and county attorney recommend the proposed settlement.
Move the county attorney and assessor's recommendation.
Motion and a second to approve the county attorney and assessor's recommendation. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Council.
Moving on to item 5, Mr. Chairman and members of the board, number 5 on the addendum agenda. This concerns Pima County versus Diana Chin. This is case number C 2013-4413 pending in Pima County Superior Court. This is a condemnation case for the Julian Wash Linear Park project. The county attorney seeks authority to settle the matter for a total of $30,000 in just compensation.
Move the county attorney's recommendation.
Motion and a second to approve the county attorney's recommendation. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Council, I believe you're done.
One more.
Oh, okay.
Sorry, Mr. Chairman, members of the board. Item 6 on the addendum agenda concerns Pima County Flood Control District versus Fidelity National Title Agency et al., case number 2013-2297, pending in the Pima County Superior Court. This is another condemnation case, this time for the Cañada del Oro Parkway, La Cholla to La Cañada project. The county attorney seeks authorization to proceed as directed in executive session.
Move the county attorney's recommendation.
Motion and a second to approve the county attorney's recommendation. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Now I believe you're done,
I
Council.
am finished.
All right, moving on to item number, Board of Supervisors sitting as other boards, Flood Control District Board, item number 7. Supervisor Carroll.
Mr. Chairman, I'd like to move item number 7, the award of the low bid award of contract, an amount of $9,261,274.29 to the lowest bidder, Ashton Company.
Second.
Motion and a second to approve item number 7 under Flood Control District Board. All those in favor, please signify by saying, I
Mr.
believe
Chair-
we do have Supervisor Miller.
Yes, I had some questions on this one. This says Phase 1 of this project. Are there multiple phases to this project?
Mr. Huckleberry.
Yes, Mr. Chairman, Supervisor Miller. Yes, there potentially are. This is a larger flood control project on the Santa Cruz River, essentially from the Santa Vera Mission to downtown. This phase, which is really about 29th Street to back towards the Ajo area, is funded and earmarked in the 2004 bond program. And so this is the bond program element. The future phases will depend upon either Corps of Engineers federal funding from the Water Resources Development Act or potential inclusion in future bond issues.
I understand that we have $14 million for this project from the 2004 bonds. Is that correct? That was the information that we got, is there's $14 million. That's why I was curious about where this other $5 million is going to be spent, or if that's earmarked for another project.
Mr. Chairman and Supervisor Miller, yes, I think the amount in the bond program is about $14 million. This is just the construction contract. There's been land acquisition already, design, and there'll be construction management. So that probably will pretty much consume most of the funds.
So some of these monies of the $14 million have already been spent on this?
Yes.
Okay, all right, thank you.
All right, there's a motion on the floor on the approval of item number 7. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Board of Supervisors sitting in regular session, consent calendar, item number 8. I don't have any cards on call to the public on consent calendar item only. Is there anyone here who would like to address the board on the consent calendar item only? Hearing none, what's the will of the board on the consent calendar?
I move consent calendar in its entirety.
Second.
Mr. Chairman, I have some questions regarding item 7 that I'd like to have that item removed from consent. I move that.
Second.
Is that a substitute?
She never got a second, did she?
Yes, she did.
Oh, okay, then it's a substitute motion.
And which item was it again? I'm sorry.
Item 7 on page 11.
I'll accept that substitute motion.
Okay, there's a second on the substitute motion. So this vote is on the removal of item number 7 from consent calendar. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Supervisor Elias.
Well, you know, I'm concerned about this item. We talked about it last week, and we approved some money to get moving on this ferric chloride issue and the struvite problem that we've created for ourselves in our sewer system. And, you know, now we have an item in front of us that we're telling the public is a 5-year contract, but in truth, we're going to spend it all in 2 years. And I just think they need to know that that's the way this item not only is being considered by our staff, but I don't want anyone to have any illusions about this being a 5-year contract. In reality, it's not. It's a 2-year contract due to our own mistakes. And so in light of that, I'm willing to move the item and support it because I think it's important that we take care of this problem and not let it continue to clog up the system and force us to do manual cleanouts of some of the pipes there at wastewater. But I would like to see a detailed report about how this all came about and whose mistakes were at stake here and how we got to the point that we didn't understand how much struvite was going to be produced by our system and ended up clogging everything up and putting us in a situation then where we're certainly within the confines of the law, but I don't think we're being as forthright as we could about how this issue has been handled. So I'd like a report on it if I could, Mr. Huckleberry. You know, like I said, it's not, we need this, and I understand that. And I understand we have a little bit of a window here, and I would have asked to continue this item till our first meeting in November, but I don't think that's the smartest thing for us to do. I want us to move forward and take care of this problem, but there needs to be some accountability for it, is my only point. So I'll go ahead and move item 7,
Second?
approval, and ask for a report mid-November. Does that sound okay, Chuck? I mean,
Mr. Huckleberry?
you have a month to do it?
Yes, Mr. Chairman and Supervisor Elias, we'll be happy to give you that report, and I think the word mistake is probably a little too strong.
Perhaps.
Yeah, these are new modern treatment facilities, and because of the nature of how we have to clean the water, we're basically, and I think we're seeing this happening in all of the new facilities that are being put in that clean water back to Class A standards, where you get this struvite deposits inside the pipes. So I think, yes, we will get you a comprehensive report, talk about the alternatives and the cost effectiveness and what we know and what others know now about struvite in this evolving technology world of wastewater
Right.
treatment.
Right, and I can appreciate that, Chuck, and perhaps I misspoke when I said mistake, but let's be honest, struvite is not a new phenomena in the wastewater world. So, that's the reason I say that. Anyways, my motion's on the table. It's been seconded, Mr. Chairman, thank you.
Any other questions on item number 7? Okay, the motion is on the approval of item number 7 on the consent calendar. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. What's the will of the board on the remainder as amended?
Mr. Chairman, I will move the remainder of the consent calendar as amended for approval.
Second?
Motion and a second to approve the remainder of consent calendar as amended. All those in favor, please signify by saying aye.
Aye.
All those opposed, please signify by saying nay. Ayes have it. Moving on to clerk of the board, item number 10, unfinished business minutes.
Mr. Chairman, I'll move the item.
Motion and a second to approve the minutes on item number A.
Mr. Chairman, I have some questions on this
Supervisor
item.
Miller.
I've been trying to get information on this item, and I have not been able to get this information. One of the first questions is that, Mr. Huckleberry, have you approved the direct select justification for this contract? We have been unable, I've been told that it's unable to be located multiple times, and we're trying to get a copy of this direct select justification.
Mr. Chairman,
Mr. Huckleberry.
Supervisor Miller, I probably have. I mean, I know I would have originally with this contract because of the specialties involved. With regard to whether or not we can probably find the piece of paper. If you've been unable to find it, it means probably we've been unable to find it.
Right.
So, but my recollection would be, yes, I would have.
Okay, I would like to...
Mr. Chairman, just a point of order. Supervisor Miller is discussing item B, not item A, and I think that's what Chris was just going to.
We have a motion on the floor for item A.
This is item A.
Oh, item A only.
I call for the
Yeah.
question.
Okay, but the reason that I'm bringing this up is
I'm
because...
sorry, the question's been called, it's not debatable. So all those in favor, please signify by saying aye.
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 All opposed, please signify by saying nay.
Nay.
By your vote, 4-1, motion carries. Now moving on to 10B.
Now, please.
Supervisor
Okay.
Miller.
Back to the questions that I had, and the first one Mr. Huckleberry has already addressed. I do have a public records request for that document, and I also would like to get all of the information that Mr. Loyola, all of the deliverables that are outlined in his invoice for what he has done on this contract, including emails, text messages, And I have the whole list, and I have his detailed invoice of everything that he's done on this project. So I am going to, since I've been unable to get this for over a month, and I have multiple requests, I am going to now submit officially on the record a public records request for both items. Thank you.
Do we get copies? Do all
I can
board
give it
members
to the
get
clerk
copies?
of the board, who can distribute copies.
All right. So what's the will of the board on item number 10B?
I'll move the item.
Second.
Motion and a second to approve item number 10B. All those in favor, please signify by saying aye.
Aye.
All those opposed, please signify by saying nay.
No.
By your vote 4-1, motion carries. Moving to Fire District, item number 11.
I move item 11, Hidden Valley Fire District.
Second.
Motion and a second to approve item number 11. All those in favor, please signify by saying aye.
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 All opposed, please signify by saying nay. Ayes have it. Community Development Conservation, item number 12.
Mr. Chairman,
Supervisor Elias.
I go ahead and move item 12, Community Development and Neighborhood Conservation. Several affordable housing projects, Alvord Court Apartments, Curtis Road Project, Green Remodeling Project, and Corona Road Estates.
Second.
Motion and a second to approve
Mr.
item number 12. Supervisor Miller.
Sorry to interrupt you. Mr. Chairman, these are the final bond monies from the Affordable Housing Projects money, of which there was $10 million from 2004 bonds. And I have a question. District 1 has never received any of these monies, and we certainly have individuals in District 1 who have significant issues with poverty. And this time, District 1 did submit an application, and it was denied. And they've never received any monies at all in District 1 of this $10 million. And I'm requesting, first of all, I'd like to know why District 1 wasn't considered or wasn't approved.
Mr. Ogilvy.
Mr. Chairman, I'm sure that if an application was submitted, it was routed through the staff to the commission, and the commission is the deliberating body that makes the recommendations to the board.
Okay. They did, the understanding I got is that it was a qualified application, but there's never been one single penny of this bond money spent in District 1, which is where my objection is. I think District 1 should at least get one project through on this $10 million bond project. So I make a motion that we continue this and ask folks to, the folks in that department to reevaluate this approval of these bond monies.
As a substitute motion?
As a substitute motion, yes.
Is there a second? Motion fails for lack of a second.
Mr. Chairman,
Supervisor Elias.
I would just say that, the commission works hard on processing those applications, and I think it's unfair to comment that they never considered any projects from District 1. In fact, I think they did consider them. I'm afraid that, or I don't really know, but I'm assuming, because I trust the Housing Commission, and certainly District 1 has had representation on that commission the entire time. So that should not be a surprise at all, and certainly they've had voice on that commission. But what I would say is that, affordable housing is difficult at best, and you need to put those funds in projects that are really ready to go and well prepared with their presentation, because it's difficult enough to do housing projects in a bad economic market, but affordable housing puts an even more difficult spin on things. So very often these projects have been about refunding existing affordable housing to preserve it. So that's another issue that has always been of concern. Certainly, all the commissioners are very aware of the notion that you should not concentrate affordable housing in any one area, as that's very deleterious to various kinds of neighborhood needs and public needs. So I would just say that I trust the commission, and I think that they've done a good job of being stewards over that money. And certainly they all come from the private sector, with the exception of one or two that are community-based kind of members. So I just wanted to comment on that in defense of them, because I think they've done a good job managing that money over the last 10 years or so.
Mr. Chairman,
Supervisor Miller.
I would like to request from Mr. Huckleberry a report from the commission and what criteria they use to analyze these various projects that they approved this time, and get that information so that we can evaluate that.
All those RFPs are made public and disseminated through the regular course of business as well as advertising. What opportunities are available to developers and nonprofit developers throughout our community. So I think that's a good suggestion. You should take a look at those RFPs that have been made public the entire time that we've had those dollars available to folks and projects that are important to us.
Mr. Chairman, I still request a report, a final report from the commission on what their analysis was, what criteria they used, and why they chose the projects that they did. That is not included in the RFP. That's a separate report. So I would like that report, please.
Does the maker and the seconder accept that as a friendly amendment?
I'd be willing to accept that, but I would ask that Supervisor Miller change her language just a little bit, in the sense that the commissioners are actually volunteers to Pima County who act on the behalf of the supervisor's offices as well as Mr. Huckleberry's office. Perhaps that her request for a report should go to staff who work directly with the Housing Commission rather than with the commissioners themselves.
Mr. Chairman, I would like to request this report as their staff in the room who can address this. There is no staff in the room, so given that they work for Mr. Huckleberry, I'd like to request a copy of the report showing the analysis and the criteria that were used in the consideration and approval of these projects, please.
Perfectly fine with it. I'm totally fine with that. I think it's an open book. I was just trying to be considerate to people who have volunteered hundreds of hours to Pima County and trying to do their job, and that we should direct our requests towards Mr. Huckleberry and towards our staff.
Mr. Chairman, just a brief comment. I certainly understand Supervisor Miller's concern, and I would have that similar concern. I think if I had no projects in my district and knew that I had affordable housing issues in the district, so I certainly understand her position and her point of view on this.
All right.
Mr. Chairman,
Supervisor Carroll.
whatever materials are going to be reviewed, I also agree that, these are volunteers. I'm sure that my district commissioners have also felt that when needed, we've gone to bat for the district and found that the stress maps are very helpful. If the stress maps have been updated, they'll indicate to all supervisors where in their areas are stress, economic stress, and areas that would be eligible for these types of funds or housing funds that could come through the bond package. So I would hope that we could get an update of those maps. I really don't know why the supervisor can't go directly to her commissioners and ask for the information. They're the ones who could recommend it from staff as well. That's what I would have done, but I'm happy to support the idea of it as long as you include the updated stress maps to indicate to all supervisors in the public any maps that we have that are stress maps could be included would be helpful. Thank you.
Maker and the seconder, okay with that friendly amendment?
Fine. Yes.
I wish we'd have some resuscitation of what's on the table now, because there's been a lot of discussion about it.
Okay, let me, I think Mr. Huckleberry wanted to address the question, and then we'll restate the motion.
Yes, Mr. Chairman, what we can do is staff will provide all the information requested, and that's the analysis, the reports from them, why these were ranked or selected. What we can't do is provide the rationale behind the votes of the commission. I mean, that's in their own minds as to, and whether or not there's minutes that in the commission will look at that to see if they had some deliberations about why they said this one versus that one. And we'll provide all that information to Supervisor Miller, copy the rest of the board, so everybody has it. It's fine.
Thank you.
Okay, so the motion before us, to the best of my understanding, please correct me if I miss it, to approve item number 12 and to add a report to that will go to Supervisor Miller, carbon copy, and the rest of the board that contains any criteria or discussion or deliberation on RFPs, as well as the approved RFPs that were approved by the Housing Commission and this board, as well as revised copies of or existing copies of the current stress map for Pima County. Is that correct? Okay. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Hearings, Board of Supervisors, item number 13, appeal of review officer's decision. Staff report, please.
Mr. Chairman, members of the board, this is an appeal by Mr. Juan Bojorquez for the reclassification of a residence he owns from Class 4 back to Class 3. It was changed by the county assessor for tax year 2013. I reviewed the appeal and have recommended denying the appeal. Mr. Bojorquez owns 2 residential properties, both in his name as his sole and separate property. He resides in one, and he has represented that his wife resides in the other. Under the statutes, in order to qualify for primary residence, the house must be occupied by either the owner or by a specific person listed in the statute as related to the owner, and they include children, parents, stepchildren, and there's a listing that is in the report to you. It does not include spouse, and the fact that Mr. Bojorquez's spouse lives in the other residence does not qualify under the statute to make it a primary residence for him. So I recommended that denial of the appeal and that it remain classified as residential but non-primary residence.
Let me ask if the appellant is in the audience.
Yeah, right here.
Did you wish to speak?
Well, I got this.
You need to come up to the microphone, give us your name and address for the record.
I bought this mobile
We need your
home.
name and address for the record. First, we need your name and address for the record.
Oh, okay. Juan Borges. I bought this home. Is
What's your address?
6149 South Barrister Road.
Proceed.
Okay, I bought this mobile home a few years back, and my wife and I were having problems, so we decided to separate for a little while and fix our problems. So she lives in this mobile home, and I have another residence here in Tucson, whereas my daughter lives there too, and so I'm back and forth, and my mother is sick in Douglas, so I spend my time between Douglas and Tucson, and going to my wife and trying to fix things up. And I made a mistake, and when they sent me the forms to set up my primary residence was on my house here in Tucson, and then I didn't know what to write down for my other residence since my wife lives there. So
You have, let me see if I understand what you just were telling us. You have 2 residents in Tucson?
yes, they are both under my name.
Okay. And I think if you listen to the hearing officer, the review officer, he indicated that based on state, and you agree that your spouse is living in one of those residences?
Right, I have all kinds of documentation.
Well, I mean, but it's your
bills.
spouse that's
Yeah,
living
my
there.
s-
Not a daughter, not a child, not a mother, but a spouse.
Well, my daughter lives on the main house.
But,
You know, on the other house that I have is 3331
but they're both registered in your name?
under my name, right?
Okay. If you, the review officer, when making his decision and recommending that it stay at legal class 4.1 for the tax year 2013, did that based on state statute because a spouse does not qualify in this instance, and that's a statutory requirement. I'm not sure that we have any ability to supersede statute at this point, unfortunately.
What happens if I change my main residence because my daughter lives there? She qualifies.
That would do
And I
it.
move.
That would do it,
And I
but,
move to my
Yeah.
61 because it's funny that my wife doesn't qualify, my daughter does. I mean, it's.
Right, no, I mean, it is, but it's a state statute, so let
We
me
can fix
ask,
that.
let me ask the review officer, at this point, can we continue this and see if he can accomplish what he has suggested? Or is this a decision we need to make for this tax year and need to make it now?
Mr. Chairman, Supervisor Bronson, it would be okay to continue this, yes, and
Okay.
resolve it.
All right.
Mr. Chairman,
Supervisor Miller.
I had a question. When doesn't tax year 2013 end? June of 2013?
Mr. Chairman, Supervisor Miller, the tax year is very confusing because although it pays for fiscal year 13-14, the tax years are actually the calendar years. So the tax that is levied in 2013 is considered the 2013 tax year.
It's a calendar year, not a fiscal year.
It's a calendar year, not a fiscal year.
Okay, got it.
And a property owner can, if they indicate that the property was misclassified, can have the classification corrected retroactively, and there is a credit granted.
Okay. All right, Mr. Chairman,
Supervisor Bronson.
I'm going to move that we continue this until our first meeting in December.
Second.
Taking a lot of, I have to work and I have to take.
Well, I know, but you have to get this accomplished so we can help you, so that's why
Okay,
I'm
So do I have to
continuing.
come back in December?
You may not have to, talk to Mr. Berg.
Okay.
I mean, if you get everything in order, you probably don't have to come back in December.
Okay, can I ask another question? What is the big difference between a 3 and a 4 as far as tax? Is there a big difference? or-
It's multiplied.
The difference is the primary residence, which is Class 3, qualifies for state aid to education, which reduces the taxes that you pay to the school districts.
But it's Imani, is there a big difference between a 3 and a 4?
Depends on your.
Depending on the
valuation.
valuation of the property, it could be $200 to $600 reduction in
This is
taxes.
just a mobile home, I mean, it's a one-bedroom mobile
So-
home.
It would be relatively small, $100, $200 then.
Is there a second to the motion, by the way?
Okay, thank you.
All right, the motion before us is to continue the item to give the applicant the opportunity to resolve the issue to the first meeting of December, which is December 3rd, 2013. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it unanimously. Franchises, licenses, and permits, items 14, 15, and 16.
Mr. Chairman, these are hearings. Is there anyone in the audience that wishes to address us on these items at this time? If not, then I will move to close public hearing and approve items 14, fireworks permit, 15, extension of premises patio permit, and 16, extension of premises patio permit.
Second.
Motion and a second to close the public hearing and approve item 14, 15, and 16. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. County Administrator, item number 17, bond ordinance amendment, ordinance number 2013-45. Mr. Huckleberry, did you want to make a comment?
Mr. Chairman, these are just two minor amendments to the 2004 bond program. The amendments have been heard by the Bond Advisory Committee, and I believe he unanimously recommended for approval to the board.
Mr. Chairman, I will then move item 17 in ordinance number 2013-45.
Second.
And close the public
Public
hearing.
hearing.
All right, any questions? Hearing none, motion before us is the closing of the public hearing on item number 17 and ordinance number 2013-45 and approving these items. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Go ahead and move to item number 18, and we're solely opening the hearing, and we will continue it to allow the neighbors to speak. If you could please come up when I call you, and you will have 3 minutes. Please identify yourself for the record. Teresa Cotter. Ms. Cotter, if you could please come up, identify yourself for the record, and you have 3 minutes.
Teresa Cotter, address 5385 Placita Caserio, Tucson 85718. And I'm here about the lot split in Caserio Estates. Okay. Dear supervisors, I urge you to deny the request lot split. The lot split isn't prohibited by the CCNRs The amendment of the CCNRs is invalid. The applicant and the staff report wrongly relied on the invalid CCNRs amendment. The CCNRs amendment is invalid for several reasons. It is not signed by the owners of the affected lots. It is not signed by all owners of each individual affected lot. And then there is no
Ms. Cutter, if
authority.
you could hang on a moment.
Yeah.
Mr. Assessor, Tom, gentlemen,
Gentlemen,
if you could please keep it down a little bit.
maybe go
We can hear
outside.
you really well.
Okay. Does this?
Okay, I'm sorry, I paused your time.
Oh, no, oh, down. Oh, okay. I don't
Okay,
know if you
please
just
proceed.
couldn't
I'm
hear
sorry
me.
about that.
Oh, no problem. There is no authority in the CCNRs, in Arizona statutes, or in the common law that permits amending the CCNRs with the consent of 75% of the affected lot owners. You know, my family has lived in this small neighborhood for 20 years. The most recent owner in the neighborhood has already split his lot once and is attempting to split it again. The lot changes may set a precedence and change the character of our neighborhood. I implore you to deny the request for the lot split. Thank you for your time.
Thank you, Ms. Cutter. Next, I'd like to call Sheila Bowden. Please come up, identify yourself for the record. You have 3 minutes.
Hi, my name is Sheila Bowden, and I live at 5370 East River Road. I'm here to oppose the lot split. My husband and I have lived in this neighborhood for just about 16 years, and we specifically purchased in this neighborhood because of the larger lots. They allow for more privacy and the beauty of the open natural areas between the houses. You know, our feelings have not changed about this in the last 16 years. We want the lot sizes to remain as they are, large. And we feel that if you allow one lot to be split, that just opens the whole neighborhood up, and inevitably there will be other lots split, and it will completely change the character of the neighborhood. And we purchased into this neighborhood because we like the character as it is, so we are strongly against splitting any of the lots. And I did want to talk a little bit about what Teresa mentioned. It has to do with it says here under 18 at the last line, the staff recommends approval with conditions. The Pima County Development Services is the staff there. We went and talked with them. There was supposed to be a hearing last month or a month before, and we went and talked with them after that. And they did not know the history of this whole CCNRs, where there was an amendment made that we all feel is invalid. There was never a homeowners meeting called. There was never a mailing called. One individual who wanted this went around to different neighbors. Actually, I think there was another person involved too. They went around to different neighbors and told different neighbors different stories about why they were seeking signatures. And no one in our neighborhood, or I would say the majority of the neighbors, had no idea there'd even been an amendment made to the CCNRs until last fall when we happened to be working on another issue. And it was quite alarming to see that someone had done this without any approval. So that's really all I have to say about it. We just really strongly oppose the lot split. We want our neighborhood to remain the way that it has been. Thank you for your time.
Thank you. And the last person is Tom Cotter. Please come up, identify yourself for the record. You have 3 minutes.
I'll try not to be repetitive. My name is Tom Cotter, and I do just want to say the plat for this subdivision prevents splitting these lots without Board of Supervisor approval. The staff gave its recommendation with conditions only because it advised the Board of Supervisors that the CCNRs had been amended. But I don't believe that the CCNRs had been validly amended. And in fact, there wasn't notice given when the CCNRs were allegedly amended. I think you've heard that 2 different people on different sides of the what's called Dead Man's Wash, with the neighborhoods on both sides of Dead Man's Wash, went around telling people about their aged mothers and got some consents. Now, whether the aged mothers were true or not true, I can't speak personally. I wonder about that. But I know personally, when I heard about it from one member, I gave my consent initially because he told me the next door neighbor, his next door neighbor had consented, but then when I called the guy, he said that wasn't true, so the next day I actually filed, or had delivered to him, a revocation, and yet my signature still appears on this alleged amendment to the CCNRs, which wasn't filed at the time it was submitted to the neighbors, but a year and a half later by the guy on the other side. So there's an issue. There's an issue with respect to those CCNR amendments. I understand that this body does not enforce in CCNRs, it's usually a civil matter, but nevertheless, this body does grant waivers or amendments to a plat, and this plat would not allow this split. And the only reason the staff recommended it is because the staff told you that the CCNRs were validly amended. And frankly, I think that there's a lot of doubt about that, and I think that we should have the opportunity to resolve that issue, and that the court or that the board should simply not rely on the staff or ask the staff, do they actually have any reason to tell you that the amendment to the CCNRs is valid? And I think that they'll be candid to say that they don't know whether it's valid or not. And so given that doubt, we just urge you not to let the neighborhood get changed and preserve the restrictions that are on the plat and not grant this lot split. Thank you.
Thank you.
All right, thank you.
Mr. Chairman, just,
Ms.
this is,
Russell.
Chris, this has been continued a number of times. Is there a reason? I mean, I know that the applicant is asking for the continuation. Did they provide a reason?
Mr. Chairman, Supervisor Bronson, the applicant did not provide a specific reason other than more time to work with the neighbors, but they did not indicate what type of effort they've made since the last continuance. So simply another request for more time.
Okay, thank you.
Mr. Chairman,
Supervisor
I'd just like to comment that the applicant did contact our office and let us know that he was in fact trying to work with the neighbors. There's a setback requirement that he's trying to work with them on. And I do have a copy of this amendment to the Declaration of Established Covenants that is recorded in the Pima County Recorder's Office on November 17, 2008. Does that make this a legally enforceable document once it's been recorded, or is there still, could there possibly be question as to the legality of this document?
Counsel?
Mr. Chairman, Supervisor Miller. Yeah, I mean, just simply because it's recorded, I mean, there could always be challenges with respect to the validity of the CCNRs. And Mr. Carter raised a really good point. That's really a separate civil matter. This is a land use decision. Your decision to split this lot is really vested in your police power, your legislative discretion. While you can consider the CCNRs, whether they allow or don't allow, that's not dispositive of your decision. Your decision is a pure land use decision, impact on neighbors, police power type of thing.
Thank you.
All right, without objection, the item will be continued to the meeting of November 12th, 2013. Moving on to item number 19, CO9-13-07, KQ Covenant Investments LLC, Nogales Highway. Staff report.
Mr. Chairman, members of the board, before you is a request for rezoning of CO9-13-07, KQ Covenant Investments LLC, Nogales Highway. Approximately 1.46 acres from the GR1 zone to CB1. As of today, staff has received no public correspondence, either in support or in protest. The Planning and Zoning Commission recommended approval with standard and special conditions with a vote of 7-0 in favor. Staff is also recommending approval with standard and special conditions, primarily because this would provide additional retail opportunities for local residents. The request is outside the Mavine Marie Behan Conservation Land System and meets concurrency considerations.
Mr. Chairman, is there anyone in the audience that wishes to address us in opposition to this item at this time?
I don't have speaker cards.
If that's the case, then I'm going to move that we close public hearing and approve CO9-13-07 with standard and special conditions as recommended by the commission and staff.
Second.
Motion and a second to close the public hearing and approve item number 19, CO9-13-07 with standard and special conditions. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Moving on to item number 20, CO9-03-05, Benchmark Mortgage Fund, LP et al., Irvington Road rezoning. Staff
Mr.
report.
Chairman?
Oh, Supervisor Lewis.
Mr. Chairman, if there's no one here in the audience to speak in opposition to item 20B,
I
which
do
is
not have
the
any
actual
cards.
time extension, I'd like to go ahead and make a motion. I'd move that in the case of CO9-03-05, Benchmark Mortgage Fund, I'd move against closure and close the public hearing, and move item B, the time extension with modified additional standard and special conditions.
Second.
Mr. Chairman?
Supervisor Miller.
I'm not necessarily against this individual getting an extension, but I think 5 years, he's already had 10 years to develop this project, and another 5 years is giving him, in my opinion, an unfair advantage over other developers who are going to have to comply with the more recent zoning and flood control laws. So this 5-year extension, to me, seems excessive, and I wouldn't be against a 1-year time extension.
It's not unusual at all for us to grant 5-year extensions in cases like this. Given the difficulty of the recent economic period, my motion stands.
I continue to support. It's a standard time period.
It's not anything unusual at all.
All right, thank you. So the motion before us is on item 20A, the motion to close the public hearing and not close the rezoning, and then to the item number B, to approve the 5-year time extension with modified and additional standard and special conditions. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay.
Nay.
By your vote of 4-1, motion carries. Item 21 has been continued. Moving to item 22, plat note waiver, CO 12-72-03, Las Primeras Lomitas, Lot 63 and 76. Staff report.
Mr. Chairman, members of the board, before you is a request to amend a plat note that depicts an 85-foot building setback line of the Las Primeras Loma subdivision regarding a 12-foot encroachment for a porch over a slab on Lot 63. Staff has received no public comment to date, except the applicant did provide an approval letter from the Homeowner Association Architectural Committee approving the request. Staff is recommending approval.
Mr. Chairman?
Supervisor Miller.
If there's no speakers, I move to close the public hearing and approve plat note waiver C012-72-03.
Second.
Motion and a second to approve item number 22, CO 12-72-03, and to close the public hearing. All those in favor, please signify by saying aye.
Aye.
All those opposed, please signify by saying nay. Ayes have it. Moving on to item number 23, an ordinance number 2013-47.
Mr. Chairman, I'm going to move item 23 in ordinance 2013-47, and as well as under transportation, items 24 through 35, and traffic ordinances 2013-48 through 51, and traffic resolutions 2013-91 through 98, and close public hearing.
Second.
Motion and a second to close the public hearing, approving item number 23 and ordinance number 2013-47, and likewise closing public hearing for items 24 through 35, and approving ordinance number 2013-48 through 51, and resolutions 2013-91 through 98. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Moving to the addendum agenda. Board of Supervisors sitting in regular session. County Administrator, item number 7. Mr. Huckleberry.
Mr. Chairman, this is a settlement of a long-standing issue with regard to the payment of prisoner housing by the city of South Tucson. An agreement has been reached. Effectively, what the agreement does is waive the interest that the county had charged on a regular basis to the city of South Tucson because they have not paid their prisoner per diem housing for a number of years. The amount is about $500,000 or $600,000 of interest, and the interest, you have to remember, is charged at the statutory interest rate, not what the real effective rate of interest is today in current market conditions. So in most cases, we are charging between 10 and 12% interest, and the interest that we receive today from our local government investment pool is about 1.5%. So there's a significant difference. Therefore, we felt in the interest of trying to reach an agreement with the city of South Tucson, we would waive the interest. In addition, there were some charges that date from 1999, and we felt that, again, trying to reconstruct the documents and what was available, it was best to offer that as a waiver as well as and in the negotiation, it was actually increased to $200,000 rather than the $159,000 of charges that really dated from 99 and 2000. We're recommending the settlement. It is in fact having the city of South Tucson pay at a predictable amount each year with a down payment of $150,000 on that debt, and then they pay interest at about 1.5% on the unpaid balance, which is roughly the same today as our local government investment pool. So I'm recommending the settlement to the board.
Mr. Chairman,
Supervisor Carroll.
go ahead and move the settlement as recommended by the county administrator.
Second.
Motion and a second to approve item number 7 and resolution number 2013-100. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. By unanimous vote, the motion carries. I'm going to ask you at this point for a little leeway. Apparently, Mr. Borkus has reached a settlement with both the assessor and Mr. Burke, and so the chair would entertain a motion to reconsider item number 13 on the regular agenda.
So moved.
Second.
This vote is on reconsidering item number 13. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. I have before me a note to the clerk. It says, I, Juan Borges, withdraw my appeal of the hearing officer's decision for the parcel number 137-19-5130. Said hearing was continued to December 13th meeting. Sincerely, Juan Borges. So he's withdrawn his appeal.
Mr. Chairman, if that's the case, then I move that we uphold under item 13, appeal of review officer's decision. I move that we uphold the review officer's decision regarding the classification of tax parcel number 137-19-5130 to legal class 4.1 for the tax year 2013.
Second.
Motion and a second is to close the public hearing and uphold the review officer's decision on item number 13, tax parcel 137-19-5130. All those in favor, please signify by saying aye.
Aye.
All opposed, please signify by saying nay. Ayes have it. Moving back to the addendum agenda, real property, item number 8, condemnation, resolution number 2013-101.
I'll move the item.
Second.
Motion and a second to approve item number 8 and resolution number 2013-101. All those in favor, please signify by saying aye.
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 All opposed, please signify by saying nay. Ayes have it. Contract and award, facilities management, sheriffs, board commissions and committee, and proclamations.
Mr. Chairman.
Supervisor Carroll.
Mr. Chairman, this includes number 8. We've done number 8. It includes number 9, facilities management. I want to say congratulations first to Accelerate Diagnostics, and go ahead and move the amendment number 1 to provide a lease at 3950 South Country Club Suite 40 and expand the premises. Second, I'd like to move that we approve number 10, the Governor's Office of Highway Safety to provide for DUI enforcement overtime and employee-related expense, $100,000 revenue. And I'd like to move that we approve item number 11, the Governor's Office of Highway Safety to provide for 10 portable breath testers. So I'd like to move those in bulk, 9, 10, 11.
What about
12.
12 through 16?
And 12 through
12 through 16, additionally, Governor's Office of Highway Safety on the balance of those items through 12 and 16. Thank you.
Second.
Mr.
Motion.
Chairman,
Supervisor Miller,
I have a lot of questions and comments on item number 9.
would you like us to see?
I would like to divide the question, please.
Divide, well, tell you what, why don't we withdraw the motion so it's completely open? Does the maker withdraw, agree to withdraw?
I'd like to withdraw, and I'll just make the motion for item number 9. Excuse me, sir. I'll withdraw my
Hang on.
motion if she accepts that. Supervisor Bronson,
Okay.
if she'll second this, let me motion that we approve item number 9, accelerate diagnostics, including the congratulatory message for amendment number 1 to provide a lease at 3950 South Country Club, Suite 470 to expand the premises.
Second.
Okay, motion solely on item number 9.
Mr. Chairman,
Supervisor Miller.
I read through this contract, and the original contract allows Accelerate to have reduced rent for 3 years to assist them with their startup phase, which I understand has gone very well, and that's fantastic for the community. The Pima County taxpayers invested $1.2 million in the wet lab infrastructure required by this company to help them in that upstart. Under item D3, the expansion of the premises, there's conflicting information in the background material as to how many square feet. That item, D3, says the addition of the expansion space increases the usable square footage of the premises by 4,551 square feet. If in item C, which is the tenant wants to occupy space A, says 4,332 usable square feet. So there is a discrepancy there. So that's one question. If we could get an answer as to what the true square footage is that they're going to be occupying.
Mr. Ogilvie.
Yeah, Mr. Chairman, we'll have Reed follow, but it could be, if it's off by 100 square feet, it could be the custodial room and the storage closet and the, it looks like, server room. That's add another 130, so let's probably add up to the numbers.
Mr. Chairman, Supervisor Miller, County Administrator is correct. From the time they originally moved in to now, they have expanded their data needs as well as their security needs for some of their lab equipment. So it was small spaces that in actuality became a part of their lease and are now being caught up at this time.
So the total square footage is in fact 4,551 square foot that they're...
That is
okay.
correct.
And then under item 4, the Pima County taxpayers will build out option space A. How much is the cost to the taxpayers of this build out?
We just received the competitive jock bids last week. I believe it came in around $160,000, I believe, plus furnishings. So that cost, we wrote the agreement to say that their amortized cost would not exceed $400,000, not knowing yet what the final furniture cost will be because we're still negotiating that design with them. So the actual amortized amount of the expansion will be whatever it ultimately is over the balance of the original lease, which is approximately 2 years.
Okay, the way that I read this contract, it says, in addition to that, Pima County taxpayers will provide furnishings. You're telling me that's going to be included in the amount that they pay back to the taxpayers?
That is correct.
Okay. And then, so they're going to be paying back, and is this capped at $400,000? Because it says the tenant will pay us back $400,000 plus the interest. Is there a $400,000 cap on this?
That is correct. The
Okay.
amortized amount will be capped at $400,000.
Okay, and then the other item I had a question on is the parking. If the Pima County taxpayers build a parking garage, there will be no charge for the use of the garage by the tenant during the initial term. I could find no definition for initial term.
Mr. Chairman, Supervisor Miller, the initial term expires the end of calendar year 2016.
So for the next 3 years, they would have free parking if they were using that parking garage.
If we were to build that parking garage, correct, which is,
Okay.
I think, unlikely.
And then if we do build that parking garage, we're going to charge the tenant's employees only $50 per space per month in the parking garage. The question here is, we charge our county employees $70 per month to park. Why are we giving Accelerate, they're expanded, they're up and running, discounted parking beyond what we give our own employees?
We should not be giving them, I think, again, the rationale was I don't think we'll be building that parking garage, certainly within that initial term, 2016. If we started now, we wouldn't have it finished by that time with design and construction. So I don't know where the $50 came from, to be honest
It came
with you.
out of the contract.
Right. I
That's what
understand.
we read in the contract. So, okay, and there's one more. Regarding the HVAC, are we agreeing, oh yes, right now Pima County practices are Monday through Friday 6 a.m. to 6 p.m. and Saturday 6 a.m. to noon to keep the HVAC up and running. And that's what we do here in the facility here at Pima County, is that correct?
Mr. Chairman, Supervisor Miller, that is incorrect. At the Abrams building, we now have 2 tenants that essentially require the building to be conditioned 24/7. That is Accelerate, and that is the family medicine clinic on the ground floor. Due to their pharmaceutical requirements and due to Accelerate's biological requirements, the building is essentially conditioned now 24/7.
Okay, so that's always been the case.
Yes.
Are they paying the additional costs for this HVAC?
It is prorated over the square footage to all the tenants.
Okay. And I think the last question I have is that the answer we got regarding the below market value rate that they're going to be getting as a result of this expansion. In the original contract, it said that we entered into on August 20th, 2012. It said that any expansion would be subject to the current market rate once they expanded. I'd like to know why we're going to give them a discounted rate, even though this company is obviously up, running, and very successful, and why we would give them a continued discounted rate beyond what we had already agreed to, which was the 3 years for the original premises. And this does directly conflict with the original contract.
Mr. Chairman, Supervisor Miller, I believe what I understood from the law department is that this is an extension of the original premises. In other words, if they were to ask for, and in fact they are, considering additional space in the building which were not defined in the option, then those spaces would be subject to market conditions. But since this particular space, along with a pending space that they're showing interest as, were defined in the initial lease as option space, then they would be granted to exercise those options at the current rate, which turns to market rate at the end of the initial term.
Okay, that I have the expansion space that says it's item C. I will tell you the number. It's on page 2 of 22 of the original contract. At all times during the term of this lease, tenant shall have the option within 6 months prior written notice to landlord to lease either or both of 2 additional areas on the 4th floor as shown on Exhibit B at then current market rate per square foot annually, usable square foot annually. So this is item page 2 of 22 of the original contract. And that's what it says in the contract verbatim.
You can certainly go back and look at that. I know at this point they are under the understanding that it's an expansion of the existing rate.
This is in direct conflict with the contract that they signed on, let's see, when did they sign this? In August of 2012, and it went into effect in August 20th, 2012, and went into effect January 1st, 2013. And the initial term was the $9.25 per square foot, and the market rate is $11.84 is what my understanding is.
Correct.
This paragraph spells it out very clearly. So I would move that we continue this item until we get this ironed out. I'd like to make a substitute motion that we continue this item until we get this clarified. This is in conflict with the original contract.
Hearing none, the motion dies for lack of a second.
Call the question, Mr. Chairman.
Go ahead, Lee, call for the question.
Question's been called. That's not debatable. All those in favor of approving item number 9, please signify by saying aye.
Aye.
All opposed, please signify by saying nay.
I will say no again because we are in violation of terms of the original contract. Thank you.
By your vote of 4 to 1, motion carries.
Mr. Chairman, I'll
Supervisor
move
Russell.
items under Sheriff, items 10 through 16. Under Boards, Commissions, and/or Committee, items 17 and 18. And under Proclamation, items 19 and 20.
Second.
Motion and a second to approve the remainder of the addendum agenda. All those in favor, please signify by saying aye. All those opposed, please signify by saying nay. Ayes have it. Moving to call the public, I do have one speaker card. Mary Ann Murphy? Okay. Please identify yourself for the record, and you have 3 minutes.
Hi, Mary Ann Murphy. I'm from 147 East Los Arcos in Green Valley. And please forgive me my voice. I got to get that work done later this month. I will. I don't know what's going on. But when I was here the last time, I said, 3 minutes was no way enough time for me. The issues I'm aware of in Green Valley, my family history of 50 years. It goes back that long. Like I said, I first visited when I was 10. I know some of what's going on. I'm trying to help my association. They don't want my help. Green Valley Council, they don't want my help. But yet I have found myself compelled to attempt to pursue the issue of responsibility, jurisdiction, right-of-way, drainage, alleys, drainage ways, easements. Flood Control sent me a report from back in 1980. Where'd Huckleberry go? This one's for him, Mr. Huckleberry. You and your pal John Bernal were down in Green Valley evaluating our drainage ways back in 1980. I find out in my reconnaissance an additional 2 drainage ways and a culvert that were not in that inspection and they haven't been maintained, they haven't been addressed. According to the Pima County record, they don't exist. So I'm trying to do something about that. Yet I run into problems like a traffic and arroyos, that committee. I want them to try to change their name back to flood control. Give the intent and integrity of our drainage ways, give it back. Arroyos is almost frivolous. The Green Valley Council, in the personage under the auspices of Stan Riddle. It goes beyond personality conflict. The man would like me to be eliminated, I'm afraid. Frankly, for the sake of the next 50 years in Green Valley. I wondered if you guys had any pull whatsoever in how that council operates. I thought I read somewhere that the Board of Supervisors granted the authority for the Green Valley Council. I'm not clear on that administrative factor. I've had all kinds of back and forth with flood control. They've asked for copies of notary signed stuff, given that I'm going to be making copies all over the place, if need be, to present to that council, to my homeowners association. I've asked the homeowners association to draft a letter to Pima County to let them know that after 50 years, once we have all our weeds pulled, and that's what we're responsible for in our alleys, they need to be inspected, repaired, maintained as need be. They're different. There's safety hazards. There's hazards to vehicles, utility trucks, everything imaginable. 90-year-old little old ladies could succumb to a rock slide. Thank you very much.
Thank you. Is there anyone else here who would like to address the board and call to the public? Seeing none, this meeting stands adjourned.